we call upon the expertise of Dean Martin Brinkley of the UNC Chapel Hill Law School, an expert in the state constitution. Mr. Brinkley, thanks for being on.
Honored to be here. Thank you.
Well, where do we start with this civics lesson? You're here to teach us. I'll start with the easy one. Why do we even need a state constitution when we have a federal constitution?
You know, we have a federal structure of government in our country, and what that means is that the vast majority of Americans are citizens of two different states. They are citizens of the United States, and then they are citizens of one of the 50 states. Each one of those systems of government has to have a framework. And so we have a federal constitution and we have a state constitution. The federal constitution is always supreme over the state constitution, and that's because when we adopted it back in 1787 and on into the early 1790s in the ratification process, there was an article that said that the federal constitution would be the supreme law of the land. So anything in a state constitution or in the laws passed by a state legislature that is contrary to the U.S. Constitution, as it has been interpreted by the U.S. Supreme Court, is essentially void. It's as if it doesn't exist. So we do still, though, have a state constitution to regulate and set up the form of government of our state. And so that is its purpose. It is there to erect a form of government, to give powers to that government, and to tell that government what it cannot exercise power over.
In regard to these judicial vacancies, primarily the Republicans are pushing a proposal that would create this commission equally divided among the legislative, judicial, executive branch that would select options for the governor to select judges when vacancies occur. How is that different than what happens presently and in history of North Carolina?
Well, it is a different system, but we haven't had just one system since the beginning of the state. From 1776 until just after the Civil War, judges were selected by the legislature directly, with no role in the governor except to fill a vacancy until the next meeting of the General Assembly. And the General Assembly was very determined on its right to select judges in that period. Beginning in 1868, and we can talk more about what happened in 1868 because it's pretty interesting if we get there, but beginning in 1868, the state changed the method to make judges popularly elected by the people, and that is the system that we have had essentially ever since. This is a new proposal that would, yet for a third time, alter the way that judges are selected in the state.
What makes this particular 2018 constitutional amendment proposal so controversial? Because even if you just follow the basic news, you've heard about lawsuits being filed to throw certain amendments off the ballot, that it rises to such an egregious matter. But you say what's old is new again.
Well, changing the way that we pick judges is something that we do in this country on a very regular basis. There's someone, I can't remember who, once said that taking the politics out of judicial selection is like taking matter out of the universe. There's always going to be something political about the manner in which judges are selected, depending on who does the picking. So as I said previously, we've had different approaches over time. This is another different approach. And there are lots of different approaches that are used in the other states around the country. Some states do popular election of judges. Some states still have the legislature do the picking. Some have a gubernatorial appointment followed by some kind of legislative confirmation process. There are a number of different models.
Do most of them work for what they do and how they fill judicial vacancies in these other states? Is it just the way it is in these states?
It's the choice that the people of that state or their legislatures have made over time about how they want to organize this particular aspect of their state government. And whether it works or not is probably a question for the people of those states. But many states have had changes in the method of judicial selection over time. We went from legislative selection to popular election of judges largely as a result of what happened in 1868 when we convened a constitutional convention to recommend a state constitution that would essentially pass muster with the federal government after the end of the Civil War and would ensure that North Carolina was readmitted to the Union. A number of the delegates to that convention had moved into North Carolina recently after the war, had come from northern states like New York and Ohio, where popular election of judges had already been adopted sometime in the pre-Civil War period. And so they brought their experience of those systems to North Carolina and changed our approach.
For this amendment, judges remain elected, and if they don't fulfill their terms, it creates the vacancy that we're now discussing, how that vacancy gets filled until the next general election. You're an attorney who's practiced and you're the dean of the law school. How effective can anyone be as a judge stepping in midstream of a term to just fulfill that term until candidates can be elected popularly?
Well, I think it is a challenge for an individual to step into a judicial term and know that they might only serve for a year and a half. Judges don't select the matters that come in front of them by and large. Those matters are brought to court and they wind up in front of the judge through a process that the judge does not create for himself or herself. And so for an individual to come in and make a contribution as a judge, my hunch is that most people interested in that role would like to have the chance to do it for a long enough period of time to make a public contribution in that regard.
Thank you so much, Dean, for sharing your insights with us.
Privilege. Thank you.
Amendments Explained is a production of UNC-TV in association with the North Carolina Bar Association and the North Carolina Bar Association Foundation.